really wanted to talk to you because I was listening to the Ricky Smiley show, and this is before John Singleton died. They said that they were fighting over his estate already.
Right,
And I was
right.
like, wow, wow,
Yeah.
wow. This is bananas, and we want to see what we can do about it. So, other legal tea, we have a special guest. We have Rodney Davis of the law office of Rodney Davis out of Birmingham, Alabama. He's an estate planning attorney, really amazing. He's a client and a friend, and I wanted to bring him on to talk about this. And I bring guests in when we have business related issues that are not in my realm of genius, because I do believe in operating in your realm of genius. And estate planning and business succession, that is not in my realm of genius. So I brought someone in who is an expert at it. And so we have Rodney Davis here, but we do have a caveat, right? Nothing that we're talking about today is legal advice. This
Right.
is information, and we just want you to have, be informed so that you can take this information and to your attorney and then develop a plan for you and your business and your family. So that's why we're having this today. So today we're talking about John Singleton. John Singleton is the director who is behind things like Boys in the Hood, Poetic Justice. I just watched Abduction like last week, and I was like, oh, John Singleton did this.
Yep,
He
yep.
did The Shaft with that had Samuel L. Jackson in it, Higher Learning, Baby Boy, Too Fast, Too Furious. I mean, and he has a whole other list of hits.
Oh yeah.
His and so he got sick. He went on a trip and he got sick and he was in a hospital. And then following that, he ended up being put in a medically induced coma, where I think he was in that coma for like a week or two. And it was while he was in this medically induced coma that his mom / business partner filed to have conservatorship over his estate. And his daughter, who was afraid that she was basically that her grandmother was getting ready to go in there and liquidate everything and prevent the assets from being distributed the way that they were supposed to, filed a motion to block it. But before the court can hear any of that, it's my understanding that John, he passed away. He passed away on April 29th, which is really sad. And then with that, so he passed away, and he did have a will. Unfortunately, the will had not been updated since 1993.
All right.
His daughter was in that will. His daughter was the beneficiary, the only beneficiary, and it didn't speak to his remains. I think he has 6 other children.
Yeah.
So there's a whole lot going on here. And so I guess I will start with, for those who are in business, like what are some things that we can put in place as business owners to avoid just the very beginning part of it? So the conservatorship that the mother was attempting over John, how can we, so that if we're in a position where we can't speak for ourselves, how can we make our wishes known?
Well, one thing you need is a power of attorney. You need to have a power of attorney because that's what you have to put in place for situations where you're not able to speak for yourself. And what it does is it allows you to make those decisions that otherwise a court is going to have to make. And so when it comes to managing assets, when it comes to managing your finances and taking care of those business affairs, you need to have a power of attorney in place that's going to, number one, appoint someone to be in charge of managing, whatever affairs you have. And number two, it's going to give instructions as to what in particular that person can handle or what they can manage. And so I think it's something that every business owner, anyone who's in business for themselves, especially people who have a significant amount of assets and affairs that they need to have handled, you definitely need to have a power of attorney in place.
When do you recommend that we get that power of attorney? Because right now, I mean, like John, I'm sure when he went on vacation, he was like, oh, I'm healthy. This is something I don't even have to think about. And then this happens. So is this something that we should get, like we should all go and find a power of attorney now? And if so, how do we set it up so that power of attorney only takes effect if something happens to us? Like, I don't want someone to have power of attorney over me and then going out and doing things as my power of attorney, under that authority, while I'm still capable of making decisions.
Right, right. So one type of power of attorney is called a springing power of attorney. It's a power of attorney where it becomes effective upon a certain situation, and most of the time that's when you become incapacitated. A lot of powers of attorneys these days, like you said, they become effective immediately, and so that's not really recommended for someone who doesn't want to give another person power of attorney right now, but definitely want to give someone power of attorney on a date in the future or upon a certain condition or a situation happening. And so a springing power of attorney, I like to think of it sort of as someone springing to your rescue, or someone, springing to, this situation
Right.
to act on your behalf. And so, and you can get this done, pretty much anytime, but you definitely don't want to get it done. What a lot of people do is they wait until, they become incapacitated, or their family members wait until they become incapacitated. And then I get a lot of calls from family members who say that their loved one or their friend or their partner has become incapacitated, or he's had a stroke, or he's in the hospital and he can't speak for himself. Can you do a power of attorney? And I say, well, I can't do it now because it's too late. And so I guess to answer your question, when should you get it done? As soon as possible. As soon as possible is when you should get it done. You definitely don't want to wait until you become incapacitated, or your family members or your friends or your business partners don't want to wait until you become incapacitated to get a power of attorney done. You want to get it done immediately, and you want to get it done with an attorney. Don't try to, use some of these online websites, LegalZoom. There's so many out there that try to sell you these forms online. You definitely want to speak to an attorney who specializes in that field of law, and someone who's who's drafted powers of attorneys for clients before. And you want to reach out to someone like that and have it done. But again, you definitely want to get it done now, especially if you're in business, and especially if you have a significant amount of assets, because the last thing that you want to do is what's happening, what happened with Mr. Singleton and his family. And, when you do wait until, you become too sick or too incapacitated to do a power of attorney, you risk the situation that Mr. Singleton's family was in, which is them having to now go to the court to ask to be appointed to manage Mr. Singleton's affairs, instead of him actually putting into writing and into place a document that he gives his own directions as to who's going to manage what and when, and things like that. So
That's really good. So, and I just want to back up just for a minute. For people who don't know, what is the conservatorship? What would that have done? What authority would that have given his mother?
Well, conservatorships generally give another person the authority to manage, the person's assets. So you're talking about a person's finances, mainly their finances. I think different states have different codes as far as what exactly a conservatorship will give you the authority to manage. I think some states even call it a property guardianship. And so there's different names, but basically a conservatorship is a court process that someone has to go through in order to be appointed to manage the assets, the financial assets, another person. It can be for a person who is a minor child, and they're, of course, they're not old enough to be able to manage their own finances. Or it could be, as in Mr. Singleton's situation, someone who's an adult who's incapacitated.
Okay, that's good to know. Well, the good news is, one of the things we see all the time is some people pass away and they don't have a will. In this case, Mr. Singleton did have a will,
Right.
but it was written in 1993.
Right.
At that time, he had one daughter, and he left his entire estate to that daughter. The challenge with that is, when he passed away, he had 6 other children.
Right.
So his will had not been updated since 1993. So let's talk about I guess my question is, how often should we be looking at our estate plan?
Yeah,
Let's start there.
I recommend at least every 3 years. I think that um, just based on my own experience and just based on the stories that I've heard from other individuals,
Hmm.
3 years. Obviously, no one is gonna have their estate plan updated every single year, and it's definitely probably not a need to have it updated every single year. But for the sake of trying to, I guess, address those life-changing situations that come up, I think 3 years is a pretty good window to consider having your estate plan at least looked at, if not updated. And you have situations where you could have had someone who passed away since you drafted your estate plan that you may have had in your estate plan as a beneficiary. They could have passed away. You could have, like you said, had another child since the last time you had your estate plan written. And so there's a lot of situations that, could occur. You could get a divorce. You could be remarried. There's all types of situations that can arise between you having your estate plan drafted for the first time and having it updated. There are a lot of situations that could occur that would make you want to change your estate plan, whether it's to add a beneficiary, whether it's to remove a beneficiary, whether it's to decide who you want to give something to that you maybe didn't address the first time. And so I think 3 years. I will say 5 years. If you get to 5 years and you haven't even looked at your estate plan, then you definitely need to have a look at it. But for me, for my clients, I always tell them that just by default, we're going to look at your plan every 3 years just to address any changes that may have occurred in your situation, and anything that may warrant you needing to change your estate plan. So
I think that's really good because what it does is basically we're going to look at your estate plan between every 3 years. That's just a set something to put in your mind. But if you have a major life change and you remember before that 3 years, you go ahead and get it done. But that 3 years just in your mind. That way, nothing falls in the crack. It won't be over 20 years since the last time you looked at your estate plan. So I
yeah,
think that's a really good. Mhm.
yeah, I was a little surprised to learn that he had drafted a will, which is good, because you have
Mhm.
so many people who pass away and they don't have a will. But I was, happy to know that he at least had a will, but to know that it hadn't been updated or even addressed since '93 was, you think about what is that? That's over 20 years, right?
Yeah,
Um,
it's over
so
20
much,
years.
yeah, so much that happens between now and then, and you can, you probably gain a lot more wealth since 1993. You've had more kids since then, and so there's so many things that change just throughout a person's life that you should consider having your plan updated or at least looked at. I definitely think have it updated, but every 3 years definitely you need to have it looked at.
Let's talk about business succession, because one of the reasons the mom filed for conservatorship over his estate is because she was his business partner. What can
Right.
we do as business owners? I know you said do a power of attorney. What else can we do to protect our business assets, um, as we're growing our businesses in case something happened to us?
Well, if you've got a business, I think one thing that you definitely need to have into place is a buy-sell agreement.
Hmm.
It's sort of like a will for business. It's kind of how I like to think of it, and it addresses situations such as when say a partner passes away, or let's say a partner decides to sell, their share of the business, to another person. You need to have something in writing that's going to address what happens when that business owner passes away, what's going to happen with that business, who's going to get, what amount of that business. And so, for example, if you've got a business and you've got, three partners,
Hmm.
at some point one of those partners passed away, well, that partner who passed away has a third of a share in that business. And so what is going to happen with that, deceased owner's share of that business now? And so that's what a buy-sell agreement does. It puts into place what's going to happen in the event that one of those owners passes away. What are we going to do with their portion of the business? Is it going to be split up between the remaining business owners? Are we going to allow someone else to come in and control that person's share of the business? You definitely need to have in place something to address what's going to happen to that, to that business owner's portion of that of that business.
So if we don't have anything written, like a buy-sell agreement, and someone, either passes away or even before they pass away, they become incapacitated in some type of way, what does that look like? What can be the ramifications of not having that in place to the remaining partners?
If you don't have that in place, then again, you have to go through the court process to try to establish who's going to be in charge of that, of those, business assets, who's going to be in charge of handling, whatever portion that person owned of that business. And so, a good way to think of it is as anytime you don't have something in writing, when it comes to either dying or becoming incapacitated, anytime that you don't have something in place ahead of time, then you always open up the situation where either your business partners or your families or your friends or whoever is interested in, your estate or particular, parts of your estate. You always open up the situation where they're having to now go through the court and ask a court to have them appointed to manage those business assets or affairs or whatever you have in your estate.
And it seems like you leave the door open for the business partners to fight with the family over, okay, so the family might want to step into that role, and the business partners are like, I don't know you. Like, you don't know anything about our business. And so because you didn't have that wrapped up, you just leave yourself open for exposure.
Exactly. And I hear, that's, that's a lot what's going on with Mr. Singleton's estate. Like you mentioned, his mom was his business partner, for most of his career, I think, if not all of it. And so, of course, she's probably, more hip to what exactly needs to be done as far as his business goes, and what decisions need to be made, where money needs to be spent, all of those things that before he became incapacitated, Mr. Singleton was doing himself. And so, with his mother being a business partner, it definitely left the door open for her to fight with, other family members, which is what was going on between his daughter and his mom before he passed away.
Right, because he has all those assets, and so now it's like, what happens to, and when I'm talking about assets, I'm thinking more about his IP, like what happens to his IP now that he's gone. It goes to the state, but so just thinking of things of that nature. What else would you want to tell the listeners, the audience, that the audience is mostly made up of business owners and entrepreneurs? What else would you want to tell us as it relates to estate planning and business succession and just having businesses in general?
Well, I think I think communication is a key part of having a plan in place, whether it be for your estate or whether it be for your business. I think that one thing that we have to learn how to do more of is communicate with our family members, with our business partners, with our relatives, and express to them, what we will want in certain situations. I think it's a given to have things in place and to have things documented, like powers of attorneys and advanced directives. But I think before we do all that, we need to start with communicating with each other. So if you're in business with someone else, one of the things that needs to come up, in the process of starting this business is, what's going to happen in this situation? What's going to happen if something were to happen to one or both of us? Let's say that you have two business partners and you're both traveling and you both pass away in some freak accident, because that does happen. What would we want in this situation? And I think it's important because depending on the situation, you just leave the door open, like I said, for your family members to come in and try to make decisions about things that they think that you would want. Um, you know, Based on your circumstances, they have to try to guess, well, what would Rodney want in this case, or what would his business partner want in this situation. And so I think definitely communicating with your business partners and your loved ones about these types of situations. We don't like to think about them, but the reality is that you can't avoid certain situations. Mr. Singleton, I'm sure he didn't know. You know, I'm not sure exactly where he was when he got sick and when he had the stroke, but I'm sure that it's not something that he anticipated happening, and so it's not something that we anticipate or something that we look forward to, but it's definitely something that we can't really avoid, and so I think that we have to do a better job of communicating with each other about these types of situations. And then, the next step is, of course, to have a visit with an attorney. Speak with an attorney who specializes in handling estate planning and business succession matters, and get something in writing, have something in place, have something written, so that when you do get to the situation, there's no confusion between your family members. There's no unnecessary drama that family members have to go through with each other. I've seen situations like this break families up. And I've seen families. Yeah, I've seen families who they've not necessarily had bad blood. I think we assume that whenever we have family members fighting over a person's assets, we just assume that, well, they've probably had bad blood between them. You have people who are always speculating and saying, things about the children and things about the parents and things about this person, that person. And the truth is, sometimes there may be bad blood, but also there may be situations where there wasn't necessarily bad blood. It wasn't necessarily a problem between two individuals. But it's when a person passes away, and you leave everyone else, to really guess, well, what needs to be done or what you would have wanted. And I think that's what causes the drama, the unnecessary drama between, your family members. And it's kind of embarrassing, I think, as a celebrity. I think it's embarrassing for anyone, but I think it's even more embarrassing if you're a celebrity, and you don't have something in place already, and your family ends up, fighting over decisions like Mr. Singleton's family is fighting over, and and so I think it's you definitely need to start with communicating with your loved ones and your business partners, and definitely after that, go visit an attorney. There may be you may think that you have everything in place that you need in place already, only to find out later that you don't. And so definitely need to speak with an attorney about, putting into place, the necessary documents that you would need in case something does happen to you.
That's really good. We got some takeaways, and we'll go over those takeaways in just a minute. But one of the other things that you mentioned was an advance directive, and one of the things that I wanted to also have you talk about is a living will. That's one of the things that people were saying, that he needs living will, and then let everyone know what an advance directive is. Are they
Yeah.
the same? Are they, what are they?
Well, so a living will is a document where you decide what types of treatment you would want in certain situations. So, for example, if you're in a coma, Do you want to be, fed through a feeding tube? Do you want to be, given medicine that would keep you alive, but wouldn't necessarily heal you? So those are just some examples where you're deciding what type of treatment do you want in certain medical situations, and you're making these decisions ahead of time, because understand that by the time a living will is needed, you're probably or most likely not in you're in a situation where you can't talk to the doctor or the physician yourself. So this living will is, it's funny. It's called a living will because it's a will, but you're still alive and you're deciding, what types of treatment you want if you're incapacitated. An advance directive, on the other hand, is where you appoint someone to basically be in charge of making decisions regarding your health care if you're not able to make those decisions yourself. I know in Alabama, they kind of combine a living will and what they call a healthcare proxy to create the advance directive. And so here in Alabama, you have a document that has a living will in it, and it has a portion where you appoint someone called a proxy to make decisions regarding your health care and your medical decisions on your behalf. And so it's kind of like two documents in one is the way I like to think of it. But like I said, you're number one, you're making decisions about what kind of treatment you will want if you're incapacitated, and you're also appointing someone to make decisions for you in the event that you're incapacitated and not able to make those decisions for yourself.
That's really good to know the difference. And it sounds like what we have here in Alabama is like we get to say our wishes, but if something's not covered, then this is who we appoint to make those decisions that weren't covered in our living will. So that's really good.
Right.
And what I'm getting from today and just speaking with you today, if I were to say, we always end our podcast with three top takeaways. And I would say the three things that I'm taking away from everything that you've taught us today is, one, you have to be prepared. You have to at least think about these things. And once you decide what you want to do, that's going to take us to point number two, which is you have to communicate. You need to communicate what you want to happen with your family members and with your business partners to make sure that they know. And then once you have communicated that, then you need to put it in writing. That's takeaway number three. Don't just leave it up in the air. Don't just have this conversation, because people will interpret what you said the way they want to. So
Right.
to make sure that you have what your desires executed the way that you want them to be executed, go see an attorney. Have these documents written up and placed in writing. And then I guess I would say, if we have a bonus, a fourth one is to review those documents periodically, just to make sure that they are still relevant, that everything you want to happen and people that you wanted to act on your behalf are still living and willing. You still have a healthy relationship with them. I've heard of stories where people have, they still have like ex-spouses on the documents and to make decisions for them. And they're like, maybe we didn't end on the best of terms. I probably shouldn't have one to decide whether or not we should pull the plug on him or not. You want to make sure that this stuff is updated so that everything that you want is executed the way that you saw that it would be. Yeah. Again, thank you so very much. I know, I'm not going to say I think, I know that this is a very beneficial podcast for everyone that is listening to the Legal Tea today. And I appreciate you coming on and taking time out of your day to speak with us. Let everyone know how they can find you.
So you can find me on my website. It's www.rdavislawoffice.com. I'm on Facebook. I'm on Twitter, LinkedIn. So any of those social media platforms, you can find me. And again, my website, www.rdavislawoffice.com. My phone number is 205-578-1597.
Cool beans. And I'll make sure to put all that information in the show notes so that you can just link, press a link and you can get there.